Defense made a motion for a mistrial. Prosecutor was up to some fuckery. Potentially damaging evidence, no basis for it. The judge specifically said, do not ask that question. Do not use that as evidence. She walked right down the path and asked the question. It may be over on Tuesday morning. Batman Bruce Wayne bitch snitch. Gerald Brooks, your constitution does not apply to me because I'm a sovereign citizen, a traveler on the land. I'm from the Moorish Empire or whatever, bitch snitch. Because they're so fucking absurd. If you want to be a sovereign citizen, just do yourself a favor first. Go to YouTube here and bitch get every sovereign citizen that's ever been before. Find me one that won. God dang, you're right. Don't go down this. It's not the path. Don't have time for stupidity. Some clever dick on the internet didn't find the great loophole in all of the world's law. Bitch snitch. God dang, you're right. God dang, you're right. Traveler on the land. God dang, you're right. Moorish Empire. Traveler on the land. Bitch snitch. Moorish Empire. God dang, you're right. Traveler on the land. Bitch snitch. Late evening U.S. people.
I met you at the sideshow at the fair. The sign said, "Turtle woman, please beware." But I went in and I just had to stare. Turtle woman, I love you, I don't care.
That'll never not be funny. Good morning. Damn it, I hate when I make myself laugh. How are we all doing? Oh, Lord. Yeehaw, we're off to the races today. It was funnier today than it was yesterday, and it was funnier yesterday than it was when I made it the day before that. See, I made a bunch of AI images of Lienette and the tortoises, but I decided to I decided to go for the dune look. See, she's riding the sand tortoise there. She's got her maker hooks to guide the tortoise as she rides through the tortoise preserve on the back of her tortoise, which if she doesn't name Shai Hulud, I will be just depressed. All right. Oh, Lord. So even if you don't think it's funny, I think it's pretty dang funny. Sorry, I didn't have time to groom the stash here. I was busy. I was a minute late because I was making myself a delicious martini with some incredible barrel-aged gin. That's not a dirty martini. That is just the color of the gin from being aged in whiskey barrels. Oh my God, this is fantastic. With the 3 olives, of course. If you're gonna do a martini, you need 3 olives. Unlike yesterday, I'm not going to wait. I know I'm going to need the power of gin straight out of the gate. All right. Good morning, good afternoon, good evening, everybody. Hi, how are you? Fine, thank you. And you, as they say here in Korea. We're going to get straight into this because we've still got a lot to cover. But first, two big announcements. Well, one's a scheduling announcement. Tomorrow, Thursday is O.J. Simpson Day. We're going to take a break from the Hales for a day or two while we watch the closing arguments in the O.J. Simpson trial, which we've been watching for about a year. Then Friday is F It Friday, where we just say F it. It's a grifty booze-a-thon day. That's your day to bring all of your money and throw it at me. Every $100 that comes in, I do a shot of whiskey. It's March 15th this Friday, so that's coming up right on St. Patrick's Day. So it's going to be a St. Patrick's Day themed F It Friday, where we're going to have a huge panel of guests, and I'm going to be drinking Irish whiskey. We've got some Bushmills 10-year and some Redbreast 12. Some of the best Irish whiskey out there. Redbreast 12 is amazing, and Bushmills 10 is fantastic as well. On our panel of guests, I got to scroll down to our panel of guests. We have so far, and more will come. These are just the ones that are immediately in the lineup. Others, they drop out when spaces become available. Others will get invites. Others will ask to come on, and we'll have a great time. We go as long as your money or my liver can hold out. Whichever one ends up first kills the stream. If you haven't seen one of my monthly F It Fridays, do not miss it. It's stupendous. We have such a great time. So far lined up, we have Danny on direct, potentially criminal Sean, that Star Wars girl Anna, Nick Starro, comedian Lila Hart, Ian Runkle from Runkle of the Bailey, our very own Flux, one of the great mods who has her own channel, Aussie Overlord Hayden, Lady Law 579, Talk with Sally. Megan Fox is going to try to make an appearance. And we've got influencer Lauren De Laguna and Steph the Alter Nerd. All right, those are the people we've got lined up so far. Just don't miss it. It's fantastic. But for you guys, a lot of you are here for the Hales. A lot of you have joined me because of the Hales, and thank you so dang much. Special announcement tomorrow, Wednesday, Jeremy and George will be here. We'll have Jeremy and George for guests tomorrow, Wednesday. So enjoy that. That'll be a bunch of fun to have them here. I wanted to sit down and fill in some of the last little bits of gaps that I have in this, and to hear some of the stuff straight from the horse's mouth, not necessarily the tortoise's mouth, just straight from the horse's mouth. So yeah, Jeremy and George will be here tomorrow. Same time. So don't miss that. All right, hang on. I'm doing this because you guys have been subscribing like crazy, and if you're just joining us on replay, you can hit the subscribe button too. Hit the like button, hit the subscribe button. Take our like and subscribe poll. We do that. If you're on replay, you can't take the poll, but everyone that's here can, because your subscriptions mean so much to me, and we have grown so much just in the past week or so. We are just this close from hitting 70,000 subscribers. We're at 69,875. We are exactly 125 subscribers away from hitting 70,000. And I just lined up our 69,000 subscriber party for the F It Friday. It's going to be the F It Friday, St. Patrick's Day, giant 69 party, where we're all going to get together and celebrate 69,000 subscribers, but we're going to be past 70 before we even celebrate 69, because you guys are incredibly awesome. So thank you very much for that. Come on over here, hit our like and subscribe poll only after you like this video. And I've already given you something to like. That intro, come on. That intro was fire. Turtle Woman. Anyway, take the like and subscribe poll. Who is your favorite character in this play, in this Shakespearean tragedy? Lienette, Judge Grudge, Septic Boy, or the Tortoises? From the looks of it so far, I seem to think that a lot of you are basing your choice on who you can stomach and stand to put together in the same sentence as favorite, because the tortoises are ahead. There's 60% of you have voted for the tortoises as your favorite character, and I think it's just because you can't stand to vote for anybody else. All right, with that out of the way, let's clear off some of the things here, and super chats they'll be read as they roll in, as well as membership chats and members joining. That thank you so much, everybody. To start us off, newest member of the Clean and Sober crew, Barbara Schrock. Barbara Schrock rocks. She's a shock rock, a rock shock, because Not only has she just became the newest member of the Clean and Sober crew, but just a few minutes ago, she sent this message. Newbie here. Hi, all. She's brand new to this channel, and you've already picked up a membership. Barbara, that is so amazing. That is so awesome. I'm humbled. I'm humbled you'll take that risk with me. I'm humbled. Welcome to the channel. I hope it's what you like. We're a little saucy. We're a little irreverent here. Cursey words happen, but also I'm not a bootlicker. I'm my own person. And you know, if I disagree with something that the chat is saying, or with that the court is saying, or even with the Hales are saying, I will let you know I disagree. I'll let you know that because I'm my own. I'm not going to fanboy someone. I'm not going to I'm just going to tell you how it is, how it is through my eyes. I hope you'll enjoy it here. Stick around for a while. Have some fun. Bifrons asks, can you eat a tortoise? Actually, yes, you can. As some of you may know, I don't think it's a thing now because of conservation and preservation, but you olds like me will know the Galapagos tortoise was on the brink of extinction, like the very, very brink of extinction, because they were being eaten by sailors. That was the big deal back in the after Darwin discovered. After Darwin was on the boat that landed at the Galapagos Islands, he did study, and sailors were using the tortoises as food. They're basically food that just walks around the deck of a ship, and they're big. They can feed a lot of people. One tortoise can feed a lot of people. So yeah, they just kind of took all the turtles on board the ships that would pass through the areas where there's the tortoises, and they'd use them for food. Literally, they're just like walking food that they didn't eat a lot, didn't drink a lot. They just kind of shambled around underfoot. And when you got hungry, you just ate one. So yeah, tortoises are very, very edible. Hey, Strawberry and Yoda, stop licking each other's ears. I'm not paying the doctor bills. Oh yeah, and for those of you that don't know, I do have 2 English bulldogs. They just kind of hang out here in the studio. So all the snorty, sniffy, heavy breathing is not me. I promise. I promise. It's the dogs. And when we get to the $100 in super chat mark, or super chats or gifts, whenever we get $100, that's when we unlock the pig dog cam achievement, and we just turn it on, and the dogs join me for the rest of the evening. So that's where we are. That's the big deal. 345 here, 182 likes. Smash that like button. Let's get on with it. Marv White, an OG member for 15 months. Weird. I didn't hear when the Great Moonshine Conspiracy will be covered. Someday, my friend. I must have tuned in late. Now for the serious comment. Thank you for all that you do. Well, thank you for all that you do, dude. Your coverage is far more entertaining than other channels. Well, I try. I try to be at least mildly entertaining. I'm always entertaining to me, but that's a pretty damn low standard. So, all right, everybody, that's it. Again. Yeah. By the way, newcomers that we got Bifrons here saying, "Hey, we have a mandate for this law. You're supposed to post feed pics on Discord." No, just kind of disregard that. those aren't real. That mother ever ain't real. Don't listen to him. Okay, we've got everything. We got all the preliminaries out of the way. We got everybody introduced. I'm happy to see you all here. We're collecting our group. We got the 350 here. That's a great place to start. So let's bring up. We're going to be finishing part 1 and then start part 2. That's where we are. That's what we're doing. And boom, bring it on up. Let's insert my yeah. Let's put my picture in here, not insert myself.
Phrasing.
Let's see. Where is the right? Here's the where's the filter? Here we are. There we go. All right. I have now joined the courtroom. I'm on the extra court cam. We're picking this up right exactly where we left off. The judge was talking about the very last thing they're going to talk about, which apparently they're going to talk about for an hour and a half. And Kaldrock has just become the newest member. Kaldrock, thank you so much for joining the Clean and Sober crew. I deeply, deeply appreciate it. That puts us further down the road. That puts us $90 away from the pig dogs. Cool. All right, let's rock.
I hesitate to say, but it's worth saying that between now and January 26th, if there are additional filings, it would be the court's hope that none of them are designed to delay the resolution of this matter on January 26th, and that we could otherwise have this matter resolved. With regard to any affidavits for violation, protocol, 30-day time frame for the state to review. There's also a potential 20 days for law enforcement to review those kinds of allegations. Those are going to follow their own time frame and path. With regard to this court's intent to resolve the evidentiary matters before the court to be adjudicated on or about January 26th, that should occur. So what that leaves us with
Is what's the final item, Judgy McJudge face?
is what Respondents Counsel filed, which is on 12/29/23 at 4:24 p.m. What's entitled Notice of Supplemental Authority, that authority being the Budlove decision, which is cited at 49 Florida Law Weekly D50A, a second DCA opinion issued 12/29. And I've been saying 4
My
days
camera's
ago,
not
and when I
centered.
read it, it was 4 days ago,
Right.
6 days ago now. The
The
court
the
obviously-
motion filed the same day as the opinion.
I'm sorry,
The motion was filed the same day the opinion was published,
I got you.
12/29.
The court's received and reviewed that. Obviously, judicial notice is taken of case precedent. It includes a motion to amend the extended temporary injunction, primarily addressing the language of the addendum, and a request to take judicial notice. So to the extent request judicial notice is granted, the notice of supplemental authority doesn't need to be granted or denied. The court has knowledge of that opinion. With regards to extending or modifying the extended injunction, let me say the following.
Say something important.
So the decision reached by the Second District Court of Appeals on December 29, as I said before, was of no great surprise to this court, and in fact, from this court's perspective, mirrors quite a bit of what the court discussed of record on 12/6/23 in this proceeding, in that this court brought to the attention of the litigants that the statutory change of October 21 and added additional language, that including the phrase, quote, directly or indirectly, unquote, and the phrase directed at, quote, or pertaining to, unquote. Those 6 words were commented upon by this court. They were commented upon in the footnote of the Strober versus Harris, issued January 5, 2022 by the second DCA at 332 Southern 3rd, 1079. This court also, as stated in the most recent second DCA opinion, most specifically, as I mentioned before, but it's worth saying again, in the concurring opinion of the Chief Justice, that the court needed to narrowly tailor so as not to infringe on the rights of the respondent. And specifically with regards to that.
Oh my God, he's gone full professor mode again.
To the proceeding of 12.
Okay, all right. He hasn't gone full professor again. I forgot. He's still in lecturing professor mode. That's where we left off yesterday, was him fully involved in professorial mode here, which he really needs to stop. He doesn't need to explain all of this crap. He just needs to get to the meat of it, get to the heart of it, make a decision, and he can put all this crap in an order. He can put all this in writing later. He doesn't need to bring it up now. Just saying.
12/6/23, this court said the following. The language that the court would propose would be, and I read orally pronounced what was the court's inclination of proposed addendum to the language. Everybody heard that. Everybody was asked to consider that. At 57 minutes and 39 seconds into that proceeding, the court, in response to counsel's comment, was kind of a consensus that really that language as proposed was I use the word stretch. I mean, just as a
We don't care,
broad,
Judge. Be a judge. Make a judgment.
definitional,
Make a decision.
pronouncement of the definition of cyber stalking as amended in October 21 by the legislature. But the court also said that it was the court's intention that the court, trying to narrowly tailor it and not to infringe on his other rights to communication and or speech, except as it relates to this person or individual, i.e. this petitioner, Ms. Preston. That was the statement of the court. The court took a break. The court provided that language for consideration, and at 1 hour, 3 minutes and 21 seconds, counsel for the respondent stated no objection to the language you proposed. At 1 hour, 5 minutes and 0 seconds.
Well, Carlos, thanks for the drive-by
Respondent's
liking. I
counsel,
appreciate that. Thank you for the drive-by
response
liking.
to the court stated we do not object.
Yeah.
At 1:06:15 seconds, the court stated,
Oh
I'm going to add the language, read again the language that I went and typed on the break and brought it to the court's attention. Again, no objection, no question, no clarification, no modification, acceptance. And then on top of that, because it was the court's obligation, and I prefaced it with Mr. Hales, I'm not suggesting you're gonna violate the terms of this, but you're entitled to know. And here I am telling you that a violation could result in prosecution, could result in contempt, etc. Understood? Yes, I understand. And then we walked away. And so to the extent, and I want to hear from you, counsel, to the extent that you feel that
Do you
this
really
opinion
want to hear from the counsel?
should change or modify, it's a request to modify the language, to the extent that you feel this opinion should modify what the court's belief on 12.6 was already the intent, maybe I didn't carry it through, that may be your objection or your argument, to narrowly tailor it by not directing Mr. Hales to take down anything prior to that date, but to prospectively follow the language in the addendum. And so what is it about that language that you think in light of Bud Love is not narrowly tailored? And again, what Bud Love does is reverses the second DC. It upholds 5 injunctions against for protection against stalking. It upholds the findings, but it reverses on the language of the injunctive relief being too broad.
Right.
It doesn't tell the court, it says what's too broad, but it doesn't say what would be narrowly tailored. It's given the trial court the obligation to invest the judicial labor to narrowly tailor it.
Well, Your Honor, on page 7, I think it does. At the bottom, injunctions which, quote, prevent communications to, unquote, an individual can be permissible under the First Amendment. Communication to her, but this is social media. No one's she has to watch the video. She has to subscribe.
That's the point. That is an incredibly valid. If you don't want to be bugged by it, don't watch it. He's not forcing you to watch this. He's not going full Clockwork Orange and propping your eyes open and forcing you to watch this in hopes of modifying your behavior, tortoise woman. You don't have to watch this. That's the beauty of the internet. If you get butthurt by someone, you don't have to watch them. You can turn it off and walk away and never, ever look at them ever again. It's pretty simple.
His YouTube account to watch it.
Yeah, but hang on.
Okay, then it says those in.
I object. I do not have to.
Shut up.
Subscribe to
It
watch
cites to the
videos.
David decision, which the second DCA says we're in conflict with, and we wanted to certify it to the Supremes.
But yes, but Judge, there's no first DCA opinion in conflict here. So therefore, this is effective. This language, I'm saying this is a clarification. This is an important opinion. I can go back and read the briefs. I'm sure there was arguments on both sides saying that injunction in this case, the Bud Love case, which really matches yours, was constitutional and consistent with the statute. I'm sure there's arguments on both sides, Judge. Until we had this clarification, that's what appellate opinions do, Your Honor.
So give me a set. So again, the court's oral pronouncement on 12-6, which was reduced to writing, which was not objected to, is there not a distinction that there's waiver?
Oh, I don't think any litigants or even trial courts can waive the Constitution of the United States. The David opinion, Judge, was when the old statute that was under the old cyber stalking statute. So what they're doing is
Justice says really is inapplicable because it was interpreting a statute that didn't include 6 words that included directly or indirectly or directed at or pertaining to.
Right, which is why this judge, I think her name was Justine in Pasco County, her ruling was consistent with yours. Her injunction had the same language. There was no objection there either because this is a new statute. You pointed it out. This is new law.
And so,
the judge is just sad that he didn't get to make the new law.
My question is, what are you suggesting should be the limitation or the modification? The motion is to modify the language. And so just for the record, so that's clear, the protection involved in or implicated in the extended temporary injunction for protection against stalking, issue 12-6, is the standard language of the Florida Supreme Court form 12.980 subsection U, with the addition of what's called addendum, which is attached to and made a part thereof, and under subsection 5 of the order enjudged, it says, please see attached addendum, and the court added the additional language. So what?
Hey guys, thanks to all of you. We just hit 69,900 subscribers. We're 100 subscribers away from 70,000. Thanks to you people. Thank you so very much. You guys are amazing. And the support you've shown me since I've started doing this is literally off the hook. Thank you so much. I just wanted to pause and thank all of you from the bottom of my heart for getting me here. We're 100 away from 70,000 subscribers. Bless all you all. May you have a happier existence than the tortoises on Lienette's Tortoise Preserve.
What is it about those 2 paragraphs that the court wrote and included as part of the injunctive relief needs to be modified? I guess I'm inviting suggestion.
It's almost a gag order. You can't go on Facebook or anywhere and mention her name. You can't mention her name, show her image. You can't do anything. That's overbroad. That's not narrowly tailored. That's what
that is absolutely. That's the opposite of narrowly tailored.
The other language, the fighting words,
utter restriction of First Amendment rights.
These are unprotected, and so and also any kind of communication to her is everything else in there is standard. This new area of gagging someone, basically saying if you go on YouTube, Facebook, TikTok, whatever they got out there, and say her name or anything about her, you're enjoined. That is a prior restraint on constitutionally protected speech. And given the conflict with the new statute that the legislature changed, this indirectly, that language, wow, it opens up a Pandora's box. So I think the other opinion is wrong too by saying you can't do that. No, you can narrowly tailor it. You can't tell them what you
can. You Taylor Swift it? That's the question. Can you Taylor Swifted?
There's certain, he can't threaten her. There's certain fighting words he can't do. That's still enjoined. But this blanket is overbroad, Judge. If he basically went on YouTube and said, by the way, there's an issue of what her legal name is, but Michelle, whatever, said her name.
There's a big question as to what her legal name is.
He's now subject to criminal violations of free speech, which is
constitutional. What are we up to? 40 aliases now?
So 2 things. One is Bud Love, as you know, is a case where parties and or litigants and or people brought into a piece of litigation in a looks like a Chapter 39 termination proceeding.
Something like that. Yeah.
Those participants were being commented about in social media. And ultimately the court said as to those 5 persons that they were being stalked, and this DCA upheld the stalking injunctions. So it's a little bit different in that the basis of this petitioner's complaint is that the postings themselves, so those were postings about a court case. Bud Love is postings about a court case that led to be considered stalking. This case is about the postings themselves being a large part of inciting and fomenting others to act, and that's the pertaining to.
All right, here's a thing which lets me know that the judge hasn't really looked at this closely, because that's the one thing that runs common through all of the Hales videos that I've watched, and I've watched way more than I can tolerate about this case. It's so infuriating, but every single video he specifically says, don't harass her, don't contact her, don't do this, don't do that. He is very specifically telling people not to do the things the judge is wondering if he's inciting or fomenting, as he's saying, which is he's clearly not doing. You watch any of his videos, and that's one thing he specifically says. You can't be responsible for someone that watches a video, gets upset by the contents, takes it upon themselves despite the creator saying not to do something, and then they go off and do it. How am I responsible for that? I'm specific, he's specifically telling people don't do that. So, a month from now, somebody watches the video and goes, oh my God, this is terrible. I'm going to take the law into my own hands, and I'm going to go and I'm going to set the tortoise free. I'm going to go and I'm going to harass this person despite being told not to. He can't control every single person on earth, and it's a ridiculous standard to hold him to. But Alan69 has a $20 super chat. Thank you so much. Chat, come on, only 100 more subscribers to go for 70,000. And by the way, Jeff, cheers, you're the best. Thank you so much. Actually, we're 89 away now. We're at 911. We're 89 away now. Thank you, Alan, so much for the support. And Tracy Fagan, thank you as well for the huge super chat. Huge. I'm not a lawyer, but the language should protect protected speech, not unprotected speech. And there's very little speech that's unprotected. I'm a sort of a constitutional absolutist. I believe it means what it says. I need to see Strawberry and Yoda. We're closing in on it. We're halfway there. Whoa, living on a prayer. We're halfway to Doggo Camp. Thank you so much. Appreciate that, Tracy. And that's it. Thank you. You're all of you are so generous. Oh, and Island says, hey, it's come to my attention that some of the people think you have an imaginary friend named Yoda. Now I just have a stupid bulldog named Yoda. Yoda is dumber than a bucket of rocks, but we have to forgive him. He was malnourished as a pup. It's a long story. Yeah, and no, Norway, DeThomasis says, I've done more than 10 cases in less than an hour. Feather, can I give you 15 minutes to cross-examine Lienette? DeThomasis, no. Yeah. Color me skeptical, not skeptical. Color me skeptical. I highly doubt this guy has ever been able to process one case every 10 minutes. Or God, in 15 cases, that's like 6 minutes. Well, that'd be 10 cases every 6 minutes. 6 cases every 10 minutes. Oh my God. Lawyer math. 15 cases. 15 minutes in and out. It's a lot of cases in an hour. Sorry. Lawyer no do math good. Lawyer have secretary. Secretary do math for lawyer. Secretary get pat on head and occasional snack. That's how lawyers work.
It's posting about her in a manner. This is how it's alleged. This is how it's pleaded. It's posting about her that's mostly causing, it's not limited to, but it's mostly causing other people to act upon of persistently, consistently following, videotaping, writing about, which included threats construed as possible harm, possible violence, financial
what?
Consequence of disastrous consequence to her and her non-for-profit. labeling her child abuser, a criminal, etc. So it's like it started that the nature of the communication that was being published was the basis of the injunctive relief, not that it's that the postings grew out of another piece of litigation.
All
What
right.
we don't know is
Now
what's
I'm
the
gonna-
trial court going to do.
Me do math, me see clock, me think smart thoughts. 15 cases in an hour, that's 4 minutes. How do I know that? Because there's 4 15s in an hour. I just have to slow down, let my brain process it. So if there's 4 15s in an hour, then there's 15 4s in an hour. So there you go. So yeah, what do you think the odds are this judge has ever handled a single case in 4 minutes? I'm calling BS straight out of the gate. It's completely unimportant, but as long as he's being picky about language, as long as he's holding people to these weird standards of this is literally what you said and there's no room for miscommunication, I'm going to hold him to the same standard. This judge, a case in 4 minutes, get the F out.
When Budlove et al. Gets sent back to the trial court. And so, number one, in that context, I'm asking you, and the second part of it, or 1A of my question to you is, what are you suggesting would be, given that I read my intent was to narrowly tailor. My intent was to not infringe on constitutional rights. I did that in the previous temporary injunction. I did that, in my opinion, in the addendum that was not objected to. And so to the extent that this opinion may change your client's view and your view about this, I'm asking what would be, you're telling me the whole thing is overly broad.
No,
Tell me where it is.
it's just,
And-
he should be allowed to post. He should be allowed to.
The injunction
freedom of
is going to
speech.
tell him what he can't do.
I
I'm not
understand.
going to
but
tell him
right
what
now,
he can do.
well-
That's for you as his lawyer to advise him that based on the court's ruling, you could still do this, but the court's ruling says you cannot do that. If I'm going to enjoin, which I have, the court's order is going to read what he can't do. And so right now it reads, based on the totality of the circumstances presented to this court in prior pleadings and in the form of evidence presented to this court on 11/29, and based on the extension of the injunctive relief, etc. So it goes on. It is therefore ordered and judged that in addition to the conditions and restrictions previously imposed, which is the standard. So that first paragraph really doesn't do anything to enjoin. It just simply says why we're doing this, why the court's doing it. And so it's the second paragraph. The respondent and or anyone under his control employed by him or in any way under his direction, including but not limited to any and all administrators of any form of social media, has the responsibility to assure that he does not publish in any form whatsoever, utilizing any media platform or conduit of information of the name, image, and or likeness, and or any information, data, photography, videos related to and or pertaining to the petitioner and or her minor child. So it's that paragraph, if you're suggesting is overbroad, what would be narrowly tailored language?
Okay, thanks, Judge. At page 9 of the opinion, it's right there. We can substitute Budlove for the word Hales. But at the bottom, in this case, the injunction
I'm really going to need to
against
read the
Budlove
Budlove
Hales
decision. I'm
do
curious
not
now.
merely prohibit Budlove Hales from having any contact with the petitioner, sending communications to the petitioner, or causing others to send communications to the petitioner or inflict some manner of harm against the petitioner. Those are fine. In addition to preventing any contact with or communications to the petitioner, the trial court ordered that Budlove Hales cease communicating publicly about the petitioner, ordering that he refrain from, quote, posting online anything related to her case.
Wait, anything related to her case?
But that involves the individuals, Judge. That's what they were doing. It's not just the case. The individuals, in fact, if you keep reading the order,
Well,
it's-
the word anything, I guess, anything related
Yeah.
to the case.
in other words, the injunctions, they said it. In other words, the injunctions from page 9 to 10, in other words, the injunctions prevent Budlove Hale from engaging in public speech about a court proceeding and the individuals involved. This content-based prior restraint on speech is not tailored at all, much less narrowly tailored. The prospective prescriptions on Budlove's Hales social media communications are, for example, not confined to constitutionally unprotected speech, such as fighting words, quote, those personally abusive epithets, which when addressed to the ordinary citizen are, as a matter of common knowledge, inherently likely to provoke violent reaction. True threats, those statements the speaker means to communicate a serious expression of intent to commit an act of unlawful violence. And those are alleged, Judge, I follow you, to a particular individual or group of individuals, or incitement communications, all of these things. To the extent the injunctions broadly prohibit him from merely making public statements about the petitioner or her case, the injunctions are overbroad and impermissibly enjoin a constitutionally protected course of conduct. It cites the statute and Crapax.
He seemed
So
Crapax.
I would just say
Crapax,
just
Bud Love,
just
right?
mirror this language. He's enjoined from this. However, he's not enjoined from constitutionally protected speech. Something like that.
Okay. Counsel sounds perfectly reasonable. Absolutely correct to me. Nothing he said I have any problem with whatsoever. Why should the judge? There's prior restraint on protected speech. I don't know what the problem is here.
Would be fine.
So I'm reading in the second paragraph of this court's addendum, which is part of the injunctive relief. All right, so the respondent and or anyone, etc., from utilizing any media platform related to and or pertaining to the petitioner and or the minor child.
Mm-hmm.
So one way to remedy that, if you're suggesting, I'm not necessarily agreeing or disagreeing, would be and or pertaining to her minor child, which is also named in the injunctive relief here being sought.
Yep.
That it could go further to say pertaining and or pertaining to the petitioner and or her minor child, that may be construed as fighting words, personally abusive epithets, which when addressed by the ordinary citizen are, as a matter of common knowledge, inherently likely to provoke violent reaction, and or true threats, as are those statements where the speaker means to.
Okay, all right. Here's one of the criticisms I'm going to have of Jeremy. The judge is talking about some very important things right now. I understand Jeremy is riled up, Jeremy is excited, Jeremy is frustrated, but he's talking to his lawyer and trying to point things out while the judge is talking about very, very important things that his lawyer needs to be paying very, very close attention to in light of this judge's grudge holding and his behavior. If you don't hear every single word he says, and if you don't adhere exactly to every single syllable he says, and it's not counsel. When the judge is talking and your lawyer is paying attention, if you're sitting next to your lawyer, let the lawyer listen. Let him listen. Let him focus. Just saying.
Communicate, etc. And that paragraph out of Bud Love could define. I can tell you this, your client's still at risk because that whatever future behavior he engages in or language he behaves in accordance with would then need to be construed as, does it meet that constitutional definition or not? But that's for somebody else to decide. But what you're saying is, I guess I'm hearing what you're saying, is that the language is currently in the addendum could remain so long as we add. Because right now it's a broad, you can't do anything, info, data, photography, videos related or pertaining to the petitioner and or her minor child. And I'm suggesting that if we add, that may be construed as fighting words, which are those personally abusive, et cetera, et cetera.
Constitutionally unprotected language, right?
That may be construed as constitutionally unprotected speech, such as.
And you can cite, by the way, I don't think wrong with the order citing Budlove, but
Well,
yeah.
I could,
Yeah.
and I would,
Mhm.
because I think I'm required to, because that is the status of the law, despite, and I keep going back to the concurring opinion, but I understand 2 versus 1 to win,
Yeah.
even within their,
And
that, as pointed out by the concurring opinion, I would say that, and I'm going to look to it. It's not a dissent, it's a concurrence.
Right.
However, it includes, quote, however, I disagree with the majority's assertion that in determining what is or what is not constitutionally protected activity, the court should focus on whether the communication is directed at the individual seeking the injunction or whether it merely pertains to the individual.
see, this language he's reading, the problem with the language he's reading is this isn't a concurrence. It's not in the main judgment itself. It's in a supplementary note that another justice has put at the end of the judgment. And these are essentially garbage. They don't mean anything. They're not law. The statements he's reading in the concurrences are not the law. The statements of law are in the main body of the main judgment itself. So, it just, the concurrences or the dissents that they file after the main judgment, it just kind of, it's where the judge says, okay, I agree with most of the important stuff, but here's where here's the one part where I disagree. Or if it's a dissenting opinion, then they say, okay, I don't agree with, and I voted against the main decision for these reasons. They're just sort of things to let you know what the judge was thinking at the time the judgments were made. So what he's reading from is not actual law.
It's a criticism of that finding or that portion of the finding, and then goes on to say, because it's based on the David decision at 189 Southern 3rd 871,
Which was the old statute, which is the old.
which interpreted the old.
See, let me dazzle you with my really expensive law school education. The technical term for these additional opinions is obiter dicta. It's Latin for incidental remarks, and what it is like I said, it's just an incidental. It's a side opinion. It's a side expression of what the judge was thinking. So it's if anyone says something is dicta, it means it's not part of the main thing. It's just like an explanatory note or an incidental expression of a judge's opinion. Well, in a losing opinion, well, in this case, this is a concurring opinion. It was an opinion from a judge that sided with the majority, but they wanted to say, okay, I agreed with everything on the most important points, but I also disagree on this one little point. This is my own little thought. So no, not dicta, dicta. But you're not wrong.
Old statute, and then concludes with, in effect, I would certify conflict with the 4th DCA's David line of cases that suggest the bright line rule on a prohibition of prior restraint.
Well, that's the great, I think, yeah.
But nonetheless, the concurrence concludes, and I quote, I conclude the trial court could enjoin Budlove from making future statements about the petitioners that incite others to violence against the petitioners, regardless of whether those are directed at the petitioners, without also violating First Amendment rights. However, the injunction right now could be construed as preventing Budlove's posting anything at all. There's two ways to go about it then. One would be to cite to the language previously mentioned, which is in the opinion of Bud Love, or the other is to simply say what it currently reads and then just add limited
No,
to
Ditka didn't get it.
future
I'm sorry,
statements
Ditka
about
didn't get a
petitioners
Super Bowl.
that do
Like, no,
or
that
may incite
that was
others
Ditka.
to
You know better
violence
than that.
against
You know better than that,
petitioners,
Bifrons.
regardless of whether they're directed at the petitioner. I don't know which one creates potentially more problems, but I think I'm inclined to go with the more specific and just take the language right out of it.
Yeah, you're not in court, Irish Rover. You're in a law
That's fine,
class
Judge.
here.
Thank you.
Your
So
Honor.
I'm not.
You're in law school now. This is not a
I
courtroom.
want to be heard. I want to hear from you. Before I'm just.
Okay.
I want to get.
This
through
isn't a judge. This is a
their
law
version.
professor.
This is their motion. So.
See, I have an
consent that you could
objection.
follow, on December 29, the second DCA ruled on a case which
I understood everything you said.
affects potentially the language that this court
You didn't
added
understand shit.
to the Supreme Court approved language that was already in effect. My intent was to not infringe on his constitutional rights. The argument is being made to the extent that I intended so. It may not have come to pass that way because this decision now says with similar language in that case that it was too broad and it remanded it back, saying to the trial court, come up with different language that's more narrowly tailored to not infringe on such rights. And they're asking the court to do so by adding language that would now limit. So it says, right now it reads, you can't post anything about Ms. Preston or her kid.
Thank
Very
you.
broad. And what they're asking is that it say,
See, now you again, this is what I was just saying earlier. This is Hale's lawyer saying, relax, just chill for a minute. We're gonna get a chance in. I understand, like, and I'm not being overly critical of Jeremy. I'm just using this as a teaching moment. As long as we're in law school here and not in a courtroom where a real judge is presiding, let your lawyer do his job. If you have something to say to your lawyer, write it down, slide it to him on a piece of paper. I get you're agitated. I get you're excited and you really want your lawyer to say something that you want him to say. Maybe it's not the right thing strategically to say. Maybe it's the utterly wrong thing to say. Maybe he's just trying to pay attention, but be calm. Don't draw fire. Don't draw fire from the judge. I mean, notice how Turtle Woman over here, she's just chilling. She's doing her thing. I mean, she's even like dicking around on her phone for a bit. She's not drawing the judges. She draws the judge's fire when she talks, but when she's just sitting there quiet, she's not drawing attention to herself. So just do it. Just let your lawyer be your lawyer. He's there. You're paying him a shit ton of money to represent your interest, and he's doing your best job. And see, this was something we saw in the Amber Heard Johnny Depp trial, where Amber Heard, she kept like going and passing notes, writing these stupid little Post-it notes and sticky notes until her own lawyer said, "Would you stop fucking interrupting me while I'm doing this? Let me do my job." So, yeah, I mean, again, I'm not just doing this to criticize Jeremy. It's just a teaching moment for everybody. Just let your lawyer do the job and calm down, be calm. Don't flail around. Don't make the judge focus on you. That's the last thing you want, especially if the judge has a grudge against you and is being overtly antagonistic to you and your lawyer. Don't draw more attention.
my intent was to not infringe on his constitutional rights. The argument is being made to the extent that I intended so. It may not have come to pass that way because this decision now says with similar language in that case that it was too broad and it remanded it back, saying to the trial court, come up with different language that's more narrowly tailored to not infringe on such rights. And they're asking the court to do so by adding language that would now limit. So it says, right now it reads, you can't post anything about Miss Preston or her kid. Very broad. And what they're asking is that it say,
He wants
To
to
the
still
extent-
be able to bully me, belittle me, humiliate me, and make money off of me.
Welcome to America,
That's what he's
biatch.
doing. And in turn, his fans on their hate groups, which I do not have, but they do, says, let's kidnap her child. Let's Baker Act them so that then we should be able to get their child taken away. All of this is coming from everything he
so if
says.
he did that, and I'm not ruling on it because it's not an issue before the court, but it's like more likely than not that if the posts were in the future about inciting others to commit acts of violence against you or your child, which kidnapping would be considered a felony, violent felony.
Yeah. Yeah, it would, as a matter of fact.
Very likely that would not be constitutionally protected. That would be constitutionally unprotected as being construed as fighting words, or
Right.
considered.
And again, there's not a single shred of evidence that Jeremy gave them marching orders to say those things. It's just some of his supporters. If it was said at all, it would just be some of his followers, or maybe just even someone who isn't even following. Maybe it's someone on her side who's saying it to get him in trouble. There is no proof as to who said it, if it was said, 1, 2, who said it, and 3, why it was said. To say that just because someone said something shitty to you means they're one of his fanboys that's following his marching orders. Yeah, you're a long, long way away from proving that.
Personally abusive epithets, which, when considered or addressed by the ordinary citizen, are, as a matter of common knowledge, inherently likely to provoke violent reaction. So Mr. Hales would still be precluded and admonished and proscribed and enjoined from saying such things.
Then let me ask the courts, what are you then going to give him permission to post on his YouTube about me?
I'm not giving him permission to do anything. I'm denying him permission to do certain things.
See, this judge has moments of lucidity. That was a perfect statement of law. That's a perfect statement of his job as a judge. The judge doesn't grant you permission to do anything. The only thing that the judge or laws do is prevent you from doing something. So he was absolutely accurate and correct in a moment of lucidity when he said, I'm not giving Jeremy Hales permission to do anything. I'm just restricting his ability to do certain things. So kudos to the judge for getting that right.
Within the parameters of what the Constitution allows.
And what does,
So let me. I'll paraphrase it. I don't need to read you the quote.
no,
I could list for you in the next 2 minutes probably 15 cases. You guys are neighbors to a great extent. I know we got an Ohio connection, whatever, but what came out in evidence is he's a neighbor of yours by virtue of his property, because I had to address. Yeah, but while you got to drive around the other way, even though your properties are closer.
and they don't.
So your neighbors. There are a dozen or more cases that say, for whatever reason, the injunctive process is not designed to keep people from being uncivil and to prevent people from being rude and from keeping people from being unnecessarily and unwanted boorish behavior towards another citizen who happens to be their neighbor. There's not a good solution for that. Not in injunctive court. There may be in another civil proceeding, but not in injunctive court. It's all about violence.
Right.
Any language construed in the future that would provoke violence
In the future,
when addressed by the ordinary citizen, as a matter of common knowledge, inherently likely to provoke violent reaction, he'd be committing a violation of the injunction.
So,
And so the
under the
court's
court-
intent would be to prescribe and prevent and to enjoin him.
Officer Clumpy McClumperstein over there.
I'm not going to tell him. His lawyer might give him advice. I don't give advice of what people can do.
Every time they film us, every single time they come up to us not going to them coming to us, filming us, Like John
Are you in
walking
public?
on a walker down the road. No
Hey,
one's
bitch.
around. We got a neighbor we're talking to. I'm on the phone with an advocate. He drives up screaming, 10 feet, 10 feet. You're violating the 10 feet. See, people, he's violating it.
Okay, let's assume that's true. That is incredibly childish. That would be incredibly childish for him to do. But it would also be funny. And above all else, that's protected speech. He is allowed to do that. Welcome to America. Welcome to America, tortoise woman, where we have freedom of speech. He is absolutely able to, he's able to film you in public because you are in public. Now, if he were to like zoom a camera through a crack in your curtains to film someone walking around in a walker inside your house, or if he were to encroach into your land and go over the back fence into the swampy turtle preserve to film something there where he was not authorized to be, that would be a different animal. And yes, I said aminal on purpose. It's a childhood thing. My sister used to say the word aminal when she was like 5, and it is genetically programmed in me to say aminal every time I say animal. So yeah, he's walking with a walker on a public street. Guess what? That's the term we need to focus on. Public. He's in public doing public things with public people in public. He gets to film you. He gets to say childish things like 10 feet, 10 feet. There you go. Welcome to America.
He's turned it into Ohio, and now we are facing charges of contempt of court.
If how much better would Florida be if it were actually turned into Ohio?
For things we are not doing.
Give me 1 minute.
Giving him the ability to do that.
Okay. So here, hold that thought. I'm going to just take a brief recess. If you guys need a comfort break, we're at 10:49. We've been going
Yeah,
since
I need
9.
to change a diaper.
All right, let's take 15 minutes.
Change your own diaper, probably. All right, that is the end of part 1. Now, what I understand happened here was that someone phoned in a bomb threat to the court. The judge acknowledges it, in a later hearing, that there was speculation at the time. I understand there was a bomb threat, but yes, there was actually a bomb threat. The court talks, I think it was in the 4th hearing that the court talks about there being the bomb threat. So somebody phoned in a bomb threat, and I don't care who phoned in the bomb threat. People that do shit like that need to be hunted down, arrested, charged, and thrown in jail for a great long time, because you are messing around with one of the fundamental aspects of freedom in America, the court system. You're messing with the court system. You should absolutely not do that. There's a lot of people suspecting that it may have been the ex-mayor because he left about 30 minutes ago. I don't know if there's any evidence to support that, or if there's any evidence to support his suspicion that it was the ex-mayor, but I just don't know. So I'm not gonna speculate on that. I'm gonna say, some fool that knew this was happening, whether I'm not even gonna speculate who it was. I have no reason to believe personally it was the ex-mayor. I have no reason to believe it was anybody around the courthouse. I have no clue. But the one thing that is incontrovertible, a bomb threat was phoned in, which is a completely ridiculous and terrible thing to do. There we go. That's it. I'm going to read a couple of things here, and then we're going to get into the second part of this, which is about 42 minutes long. After they resolved and found that there actually is no bomb. But before we do, we've got to get through some of these super chats here. We are, oh my Lord, we are 43 subscribers away from 70,000. 42 subscribers away from 70,000 now. Vince Clortho says, I'm also curious about Bud Love, etc. Yeah, I'm gonna have to get a copy of that case. It sounds very, very interesting. And I want to be able to comment with a little bit of authority or a little bit of knowledge on it, rather than go, interesting thought, Judge, interesting thought, counsel. Alan69 with a $2 super chat. Jeff, how much to go for Doggo Cam? Let me think. Don't make me think. We are about $40 away from Doggo Cam. That's about where we sit, about 40 away. And Tracy Fagan, should the judge have read and understand this new law? Well, see, the interesting thing was this new decision, this new high court decision apparently came down the same day that this motion was filed. So it's a very, very new case that was just days old when this hearing happened. So give them a little bit of leeway on that. Dogs, oh yeah, again, about looks like we're about 40 away. And just some other comments that I highlighted. So when does Jeremy get to present his side of the case? Well, as far as we're on hearing number 3. As far as I know, we've done 5 hearings and we're still not there yet. The judge still hasn't got this thing to where he gets to say much in court. So, yeah, not yet, I believe, is the answer to that. And Lowlands, hey, Lowlands, Angie, what's up? Is this real time? Do we know it? It's not real time. This was January 4th. This was the 3rd of so far 5 hearings. Do we know what the lawyer thinks of the judge? No. The lawyer is going to say nothing but wonderful, amazing, nice things about the judge because this hasn't been decided yet. I'm sure the lawyer will have some opinions after this is decided, but whether or not he ever voices them, because this is a lawyer who has to practice in front of this judge. He's in fact in yesterday's part 1 hearing, he was mentioning that he's got another case in front of this judge in the very near future. So they have to work together. He's not going to, you don't see a lawyer saying a lot of crap about the judges that they have to practice in front of, at least not publicly where people have any problems with it. Does the lawyer have a strategy to deal with this kind of judge? I guess so. I hope so. But again, the problem with this is it's hard to work. You got to work around them. Hey, we've got 666 concurrent viewers here. We've got Satan in chat. Oh, three of you just bailed. We don't have Satan yet. Dang it. We had Satan chat. I like calling it Satan chat. 666 viewers. But we have 430 likes. All right. Let's see here. What are we looking at? Oh, Jeff, do you have a Doc Holliday hat? I assume you're referring to Val Kilmer's hat in Tombstone. I have a hat that kind of looks sort of like it. It didn't look like that, but Yoda, who just yipped there. What are you looking at, dumbass? Barking at the sky again? Yoda, who was just yipping there, ate one of my hats. Ate one of my beaver pelt hats. My beaver fur hats, I should say. And I sort of reshaped it to sort of kind of look like that. So yeah, I kind of have a sort of Doc Holliday looking hat. I have to wear this one again. I wanted to wear a different hat tonight, but this was the one that was on the kitchen table and I was late. So I just grabbed the nearest hat. So I think I wore this the other day. I try to cycle through my hats a lot, but anyway, that's my story. Butkus, I don't know. He passed away recently though. This is about whether he had a Super Bowl. I think he has I think Butkus way back when he was playing for the Bears had a few Super Bowls under his belt, but yeah, he died in October of last year. Dick Butkus was a mean SOB. I remember watching him play. Liz Bott says Aminal. Yeah, it's like my sister, she would just say Aminal all the time, and so it's just kind of programmed into me. And like spaghetti, she would always say scabetti. And elephants were fulminants, which I think 50 years later, I think fulminants is one of the funniest damn things I've ever heard. But love you, sis, if you ever happen to see this. Alan69 says, okay, let the dogs out. Cheers. We are looks like we're there-ish. I may have miscalculated, but I erred on the side of caution, but yeah, no. I'll take it. close enough. Anyway, keep those super chats coming as we go. We are now 35 subscriptions away from 70,000. Are we going to get to 70,000 in the next hour? It's possible. So if you haven't hit that like and subscribe button, please do. We've got 660 concurrent viewers. We're going to get right back to this in about 2 minutes or less. We have our like and subscribe poll. Our like and subscribe poll, after you hit that like button, hit the subscribe button. If you are subscribed, just double check to make sure you are still subscribed, because everybody should be subscribed to me, because that would make me incredibly happy. Take our like and subscribe poll. Who is your favorite character? It hasn't really changed much in the last hour. That's very interesting. We're kind of right about the same numbers we were an hour ago. 19% of you say your favorite character is Lienette. 13% of you say your favorite character is Judge Grudge. Only 7% of you say your favorite character is Septic Boy. And a full 61% of you, 61% of you say your favorite character is the tortoises. And again, I'm thinking that probably the reason you find the tortoises to be your favorite character is that you just can't bring yourself to vote and to use the word like Lienette and favorite in the same sentence. So that's kind of what I'm thinking. But also, as I said, we've got to that point of the show, which I call Release the Hose, where we bring on our co-hosts for the day. We got them both here. This is Strawberry on the left. That's Strawberry there with the brown, and that's Yoda's butt. So that's Strawberry and Yoda. They're both kind of sitting here keeping me company tonight. Hey, doggos, what's up? My little pig dogs. The pig dog cam has been unleashed. All right, and we've got 200 if you haven't done your job. Get down there and hit that like button. All right, so here we are with the doggos. We got the dogs out, and let me bring up part 2, and the dogs are going to be relegated to a different window. So this, let's see, bring this up. The dogs are going to be down here, if you don't mind. We'll put the dogs right down there. Or should we move the dogs over to the bottom? I think we should move the dogs over to the bottom left. Let me do this real quick. It's easy peasy to move these things over here. Bang. There we go. Update layout. There we go. Doggos have been moved over to the bottom right-hand corner, over by Turtle Woman, where hopefully they don't get sepsis. Devens Moore, I feel sorry for the tortoises dealing with it. Probably has them shell shocked. Yeah, I see what you. That's good. Yeah, good. All right, we are 25 away from 70,000 subscribers. People, you guys rock. All right, we've got to rush. We got to rush this. I got to stop interrupting the court, because we got 42 minutes of hearings to get through and exactly 45 minutes of showtime left. Yeeks. Hey, what's up, Jules?
Court's back in session. It is 1:30 p.m. Despite the court's intention to reconvene after a brief recess, unexpected occurrences outside the court's control and the litigant's control required us to take a more lengthy break.
It's a bomb threat.
Nonetheless, we are back of record, and we're in the process of discussing, and I think, at least from the court's perspective, came to a potential resolution on modification, potentially, of the injunction language in light of what is styled as Bud Love versus, actually it's the one I've got is versus McCoy, but there's 5 separate
McCoy, he's dead, Jim.
Case decided 12/29.
Hey, been there, done that. What's up, brother?
District Court of Appeals. It starts with 2D 22-1549 through 1553, but nonetheless, similar issue. So, Ms. Preston, I was asking you, or giving you opportunity to discuss what the court is inclined to do, consistent with the law, which is, and quite frankly, while we were on the extended break, the court typed up language that
I haven't seen Liz here today,
syntax
Jules.
Right, and everything came right from the second DCA opinion, and in effect, the way it reads now would include language That is very similar. It is similar to what it was, which is the respondent or anyone under his control, etc. And then where it reads, cannot post in any form whatsoever, image, likeness, etc., pertaining to the petitioner and or her minor child. And then what I added was
Okay,
that
so
would consist of constitutionally unprotected speech,
Hmm.
such as, and then this is a direct quote from the opinion,
Thank you.
fighting words, those personally abusive epithets, which when addressed by ordinary
Not
citizen,
epitaphs,
are, as a matter of
epithets,
common
Judge.
knowledge, inherently likely to provoke violent reaction. Quote, truth threats, quote, those statements where a speaker means to communicate a serious expression of intent to commit an unlawful violence to a particular individual or group. Incitement directed at producing imminent lawless action and likely to do so, and all the cites to the relevant case law, including but not limited to Cohen, Virginia versus Black, Counterman versus Colorado, Brandenburg v. Ohio. And so it basically
Brandenburg v.
precedents, and
Concerto.
I think you said that you understand,
Sorry
you
for
may
all
not
you music
like
buffs
it,
out
but
there.
it's the ruling of the court. And right now, and you've heard me go back and forth.
Oh,
Last time,
Yeah, I said I wasn't going to do this, but I have to do a thing here because we have a double play here. John H 2004 says for dog treats. Oh, thank you so much. That is so sweet. Thank you very, very much, John. I appreciate that. I'll make sure they get extra treats. Great content. You entertain my mornings. Great job, mods, and thanks. Hit that like button and subscribe. I just got a notification saying this is John H 2004's first super chat on a live stream. Thank you so much, John. I appreciate that. And not to be overshadowed, but KGIT. My doggo would like to see your doggo. Well, here's the doggos down there in the bottom left-hand corner, right underneath your deal. Also, I got a message saying this is KGIT's first super chat on live stream. Thank you. Two first super chats on live stream in a row. That's amazing. Thank you so much. And Lois Thomas asked, when is the next hearing? If you mean like hearing number 4 that I'm going to be reviewing, that'll probably be on Monday or Tuesday of next week. When is the next hearing? If you mean hearing number 6, I don't know yet. I haven't got to hearing number 5, so I don't know when hearing number 6 is scheduled for. So thank you very much for the inquiry. Let's get back to this. Thank you so much for the super chat, people. I deeply appreciate it.
To the court's understanding, and I think it's still accurate, there were no appellate decisions. It's what we call kind of a case of first impression. Since the statutory change, there's now a case decision. It's the Second District Court of Appeals, and although we are in the first DCA, DCA. The first DCA judges have the authority to say, we understand what the second is saying, but we have a conflict with their view. Our view is different, and it goes to the Supreme Court. But as the trial court, circuit court, I don't have that authority or jurisdiction to do so, meaning that we're bound by that decision unless and until either the first rules differently or it goes to the Supreme Court. And to some extent, this opinion that we're talking about here today.
Yeah, so maybe someone here in chat can tell you when hearing number 6 is scheduled. I personally don't know yet.
Supreme Court. So there may be clarification, but basically what the court is inclined to do is to modify the language.
Win for the Hales.
What was previously imposed to at least cover between now and January 26th, I believe, is when we said we would return. And
so what's he legally going to be allowed to do to me?
so I'm going to repeat myself.
Do to you? Do to you? What's he legally going to be allowed to do to you? Again, you're not paying attention here. And you were the one that said you have an amazing memory that allows you to remember everything. The judge is not allowing him to do anything to you. He is limiting Jeremy's ability to say and do certain things regarding you. The judge doesn't say you can do this or you can't. He can say you can't do this, but he can't say you do this. He can do anything that the judge does not tell him he can't do. Unless the judge says you can't do it, he can do it, unless the act in and of itself is an illegal act. So call on that mnemonic photographic memory or whatever it is you claim to have, and remember what he said a while ago. He is not telling anything about what he can do. He is only saying what Jeremy Hales cannot do in regards to certain things. So what can he do to me? Ugh. KGIT, new member again. Thank you so much. Oh my gosh, I'm so humbled by that. I deeply appreciate it. Thank you very much.
I think this will be the third time. I'm not going to advise anyone. I think in one of your motions said it's an advice. You're asking for an advisory opinion, and I don't give advice. I give rulings. And so
occasionally,
I'm not providing Mr. Hales advice. His lawyer would do that, but I'm prohibiting certain conduct. So what you're asking is, what can he do by order of the court? I'm ordering him not to conduct himself in such a manner or to commit certain acts. But he's got to decide what he can do.
Yeah.
If it's actionable, the proper authorities will look into it, and potentially this court even. And it's not an idea of setting him up. I don't want that, because it creates problems for him. It creates more litigation.
They video me every day. They video me every day.
You get to do that when you're outside in public.
And even though we're not violating the orders, they are. They edit it, they piss it, and then they have me charged with crimes in Ohio.
Let me try to address that. So
this should be
you
good.
may have misunderstood or not fully accepted what I said.
I
know from a motion filed by on Mr. Hale's behalf by his counsel, from my perspective, they didn't understand what I was trying to say. And maybe I need to clarify. When I was talking to you and questioning you about your previous allegations about how things proceeded in Ohio, far from defending you and criticizing the Ohio court, the complete opposite was my intent, which was, if you're saying you were, and I'll use the word, railroaded by that court, not heard by that court, not fully heard by that court, were denied due process by that court, or anything similar to that, like that, or in any way to be construed that way, that's for you to fight with them.
I get that, but
in no way
was
I suggesting that any of that is accurate, because I don't have a basis to know what transpired in that court. And so what you're saying to me now is, you anticipate, maybe reasonably, maybe not, I don't know, that Mr. Hales is going to conduct himself in the future as it relates to that court order in violation of that, or saying you're in violation of that, whatever it is. And you're going to have to litigate that there. There's an exception to that, but it's not relevant yet, maybe never, which is, under full faith and credit, an alleged violation of the Ohio court order would then require this court to evaluate that order in light of the circumstances and the facts, and hold an evidentiary hearing and see, was there a violation of that court's order?
He bypassed you all and went right to Ohio. We have court on.
Again, and some of you are pointing out here in chat, the order ain't against you. They ain't against him, Lienette. It's against you. There, nothing in that order in Ohio says what he can or cannot do. It only says what you can't do.
On the 10th, for contempt of court, and he's asking me to pay his lawyer fees and everything and be punished for things we've never done.
And you get a hearing on that.
Plea to a circuit court judge in Levy County, Florida,
because
that isn't being asked to pass judgment.
Right? No, I don't want
whether
you
there's
to.
been a violation.
I don't want him to film me, because the more he films
Well,
me, the
tough
more
shit.
he turns in there, and we're not. He drives by our house. He drove by the other day.
Okay, so
Or
here's
she
the thing.
did.
Here's the thing. If you're not understanding,
I know. I
want
just want to explain something.
No, but what you're explaining to me is what I would call your purported or proffered, quote unquote, defense to any accusations that may be made against you in Ohio. But you're telling it to a judge that doesn't have jurisdiction to rule in your favor or in his. It's not an issue.
It isn't about, it's
to be
about
adjudicated.
stopping it here, then there's nothing they can do there.
Right, but here's the thing. You're saying to me that this gentleman is committing acts that put you in a light unfavorably with another court. And you're going to ask me to make a decision that's true or that's untrue?
No.
You're going to ask Ohio to
No.
make a decision that that's true or untrue.
No, sir, I'm just trying to explain to you that if I don't get a full protection order that keeps him to leave me alone completely, I'm gonna
You
lose
are-
my daughter, and I'm gonna have to go to jail in Ohio or pay him money for things I've never done.
If the facts are, as you say they are, an Ohio court judge and the court in Ohio finds the facts as you say, you will be found not responsible for violating the injunction and you will not go to jail.
If what she says is true, and the fact that what she says is true being true,
evidentiary hearings and make determinations of
probably ain't that
credibility,
good.
weight, relevance, etc. But what you're asking for,
Lowlands Angie says, what is so confusing? Let me try to do this real quickly here. He has a personal protection order against her in Ohio, saying that she can't do certain things. She is she's apparently being filmed in public places in Florida. And she apparently is violating the terms of the Ohio order, which is actually it's effective everywhere in the United States. And so he tells the judge in Ohio that she's violating this order that this judge in Ohio said. But she's saying she wants, she didn't do it. She didn't violate anything. And she wants this judge to give her an order saying that Jeremy Hales can't do anything. He can't film her, can't look at her, can't talk to her, can't do anything whatsoever to her. And this judge is saying, I can't do that. If you think that his assertions about you violating the order in Ohio are wrong, go talk to the Ohio judge. And if you're able to prove your case, then the Ohio judge will find you're not breaking the order. He says, that's not my circus, not my monkeys. That's kind of what he's saying there. Hope that was confusing. I mean, unconfusing. I hope that was unconfusing.
this precedent is what you're getting. You're asking for, I forgot the phrase you just used, an injunction to the fullest extent of the law, whatever. You're getting not only temporary injunction to the fullest extent of the law possible, it's over Mr. Hale's objection, because his lawyer a couple minutes ago said, because you caused this particular extension, I should dismiss it. And I'm not doing that. Under the circumstances, it needs to stay in place, but the law requires the court to modify it.
I did
And
it
I'm
because
doing
my
so.
mother was
To the
dying.
extent-
He did it because he had to do a storage wars video on the 2nd of last month, not
And I may have
Hush,
put that
hush.
in maybe the 6th or 7th
Hush, woman, hush.
chronological motion that I've already addressed,
Yeah.
which said under 784, whatever, 0487, that's under the purview and the investigation authority of the state attorney and or law enforcement, and or maybe come back to this court. It's not yet.
Maybe come back.
I know you've made that allegation. We haven't even gotten to the real allegation that this court is obligated to adjudicate on its merits, because I tried to do so November 29, offered to do it November 30th, got a little further maybe, and then did it because of the continuance and good cause for it, 12-6, to come back 1-4, but intervening was the 12-21 non-deposition, non-discovery, and here we are with a court order to say we're all conducting discovery in a certain manner, with deadlines in a certain manner, with a return to court. I got to pull the calendar. I think it's Friday the 26th.
26.
So I've addressed.
People, I got something to show you real quick here. I got to show you something real quick, and I'm sorry for interrupting our regularly scheduled program for this, but there we go, people. 70,000. We just hit 70,000 subscribers. Thank you so much, people. Seriously. You Hales people are amazing. Thank you so much from the very bottom of my hard, cold, crusty, dirty old heart. I appreciate it more than you will ever know. I've been doing this less than 2 years. It'll be 2 years on May 2nd, and we'll have a huge blowout for that. Getting to 70,000 subscribers in 2 years, in less than 2 years, is insane. It just doesn't happen to the vast majority of people. So thank you so much for your help getting me there. It's onward and upward. We're 30,000 away from the elusive 100,000K. Get my little silver YouTube plaque, and I'll kind of put it back there somewhere where we can see it. But from the absolute bottom of my heart, thank you, all of you. You guys are amazing. I love each and every one of you, and thank you for being here. All right, let's get on with this. That's enough of this big old, unmanly hug fest. But let's get on with it. Thank you. Seriously, this is a big moment. Thanks. All right, let me bring this up.
Anymore.
I understand.
Your Honor, maybe you heard of one minor point, not about that issue. I understand your ruling. If the court so pleases, I get it. It's 16 days, whatever it is, to the 26th. But Judge, there is another minor. I raised it before, but I wasn't clear, and I didn't understand the layout. There's a main entrance from the public road that he needs to have sometimes deliveries, and sometimes he wants to pick up stuff in his truck. We have it so many feet. I'd like to ask people have egress and ingress to his property using public roads, because the main entrance, it's too much of a hassle for him to get someone else to do things. He can't conduct his business. But he's not going to come near the property. He's going to be on the public road entering his property. That's it. Because the way we have right now, the main entrance, which is she's the direct neighbor, it's the footage would be a violation because it's 12 feet or whatever.
Would you say main entrance to the Hale property?
Yeah, it's there's a conflict between that and public access to his property.
Legal rights to
I don't see how she's harmed by that, Judge. She's not going to enter her property.
Hang on, tell me what's different than what we heard before, which is it's inconvenient. I understand that, to go the other way
Well,
around.
then I can ask. Would you like?
Yeah.
Okay.
Number one, you're keeping me legally away from all of my property.
No, we know that. Why? Let me ask. Can I ask a question? Can I?
Wait, okay, right. So, Mr. Hales, that is not I'm not removing anyone from their property. I'm just trying to avoid temporarily, till we adjudicate the rest of the case on its merits, you having to, even though there's inconvenience, going around. And it may simply be, like, for instance, we're referring to the main entrance. I haven't been to your property. I don't know how it's laid out. I don't know how the ingress and egress works or why it's necessary.
Somebody can find out. Can you describe what is the footage restriction against you from contacting her geographically? Does that affect your ability to enter the main entrance of your property?
I have multiple entrances.
Okay.
It affects my ability to be at all entrances, and it affects my ability to be on all of my property.
It's only one entrance, so that blocks you, right? We potentially violate two. Okay. Okay. How so? How is that?
Hang on. Counsel, I'm gonna place-
Now, what they were saying before is there's the main one that apparently the main one comes very, very close to being within this 500-foot prohibition range. I think they decided it wasn't like their front gate was like almost right there to where the gate itself isn't within 500 feet of her place. But if you open the gate and go out of the gate, it may be. But there's another access that if you drive around about an extra mile, drive around the property, you can come in through another entrance. It seems to be that's what they're taking care of. That's what they're talking about here. There's two entrances. One may be close, and the other is like you have to go an extra mile.
Both persons, apparently,
Sure.
there may be a evidentiary determination needs to be made if there's a dispute of fact. So, Mr. Hales and Ms. Preston, if you can each raise your right hand on this issue
Oh,
of
we get some
where you
testimony.
all reside in relation to each other. And I don't know if reside was even a proper word, but own property.
There's some real courting going on here.
So we swear or affirm the testimony you have to give in this cause will be the truth, whole truth, and nothing but the truth.
I do.
I do.
Okay, Mr. Hales, Mr. Shockett, you may proceed.
So, Mr. Hales, does the way the injunction is written, does that prohibit you from accessing your property at two entrances?
Yes, multiple entrances.
Okay. Before the injunction, what entrance were you using to enter your property mainly?
It would be the north entrance.
And is that directly opposite the public road from her property?
It is directly opposite from her property.
Okay, so if you, as you approached your property, describe for the judge. It's left and right, one property on the left, one property on the right, either direction. Is that right?
Didn't understand your question.
Okay. When you're driving to enter your property in the main entrance, you're on a public road.
Yes.
As you approach her property, you would be in violation of the geographic restriction of the injunction.
Correct.
Okay.
And is that because you're within 500 feet being on the road?
Yes, I own 70 acres. I own all frontage on the road, and this is keeping access to all of my property. So
When you're accessing the main property, are you entering her land at all?
no.
Even the curtilage of her property?
No.
You understand what I mean by curtilage?
That's-
Whoa, settle
Okay, no.
down there, woman. You hear her whispering,
And why is
liar.
that entrance?
liar.
How are you prejudiced by not being able to use your main entrance?
I'm a landowner. I should have access to all of my property. I should be able to enter my property. Beyond an inconvenience, it's my legal right to have access to all of my property, doing business. For example, a neighbor contacted me and said in the middle of the night, hey, one of your gates is open. And based on this injunction, I couldn't even go and see what was going on my own property. If there was a trespasser, if there was, you name it. And the gate swung open and it was in the public road. And based on this injunction, I can't even go and take care of my own property and the gates.
So what are you asking the court to allow you to do?
Shut up, Lienette.
Utilize and be on all of my property and utilize the entire road where my property has frontage, North Otter Creek Avenue.
That's it, Judge. I understood it wrong, Judge. I think that there was some other entrance that was equal to this main entrance. I didn't realize this is the main entrance to the property.
So let me just follow up. So there are parts of your property, when you're standing literally on your deeded property, you'd be within 500 feet of the edge of her property.
So yeah, except for the record.
Yes.
Okay. So it still doesn't answer the question, why would you need to drive on the road to gain access? So if you drive, let's say you drive in conformity with the prior court order, which requires you to go all the way around the long way in a different way, but the court modified it to allow you to remain, so long as you remain on your deeded property, even if it's within the 500 feet, and you're not otherwise violating the terms of harassing her or bothering her, or whatever kind of thing, that you could remain on your property as an exception. But without I'm not hearing that there's a reason for you to drive on that road. You can drive all the way around and then walk to the front of your property.
About that gate. That's what's critical.
Or drive to the front of your property.
You have the aspect of there are pieces of my property that I have to care for. For example, the gate blocking a public road.
But what I'm proposing
You have
is
access.
Listen,
Let him talk. Let him talk.
If the court allows you access to all, so your property, big square, all your property, parts of it, as I understand, are within 500 feet. If the court allows you, so long as you remain on your property, your deeded property, even if it's within 500 feet, and you're not otherwise violating the terms of the agreement, that exception can be built in. It still might require you to drive around to come in. It just keeps you from driving in front of her home.
right.
One of my access points are in front of her property.
Right. So tell us.
There's
can
no
you tell us
driveway there. No driveway.
Shut up until it's your damn
That's fine.
turn.
I place you under oath because I expected you're going to give me contrary testimony and
I'm
then I'll have to make
sorry.
a decision.
I drew a diagram.
Can you tell the court why you need access to that particular entrance using the public road across from her property?
The only way to get access to the entrance is through the public road.
I even-
Is there anything special about the width or a gate from that entrance that makes it the main entrance?
It is not the main
Shut
entrance,
up,
but any
Lienette.
maintenance,
Shut
anything
the
that I need
fuck
to do
up.
currently under the temporary injunction would illegally
Shut
keep me
the
from
fuck
my own property.
That's been taken care of now.
Okay.
We're talking about the
Shut the
public
fuck
road.
up, Donnie.
The public road is the only access to that point. To
Well,
multiple,
why do
so
you-
three of my access points, two of those points, the only way to get to them is going to be all three of them on the public road. But the one across right from their property where they purchased property across from me is literally right across.
Your Honor, it's really, we have a case that's parallel to this, with other neighbor case, if you know which case. And in that case, the injunction did issued by, I think, might have been Judge Browning, but it doesn't matter, did allow egress and ingress to the property because they were so close.
I've carved out exceptions all the time. I mean, in Gainesville, I carve out
He
exceptions
should
to
be
allow
able
one
to
student
use,
to enter the
access,
property
and
who left the
engage in
other
commerce
side
on
to
every
class
square
through
goddamn
one
inch of
entrance
the
and have to
property
exit
he
through
owns.
that entrance between the hours of this.
I'll tell you what, go to Utah and tell someone that they can't access their own farmland, they can't access their own ranch land. Yeah, that would go over like a pregnant high jumper. You should be allowed to access every damn square inch of your property that is lawfully deeded to you in any way you see fit.
The hours of that.
Wow.
I've carved all kinds of exceptions.
Okay.
To not unnecessarily encroach upon what would otherwise be the free use of one's property.
I don't think
My
there's a
question
reason to
is,
necessarily
how can you
infringe
not have
it.
access to your entire deeded property from entering that property from another location?
The answer is very simple. The temporary injunction that puts a 500-foot restriction on me, I clearly cannot get to all of my property because they stalked me
No,
and
but I'm saying
purchased property
if
right across
No,
the street.
I know
from
what he's
me.
saying, Judge. May I, Judge? I think he's saying
Did
even
not-
accessing his property from the public road, he might need to access for maintenance or anything like that.
I've
Just
had to.
well, okay, but that's fine. But I'm just saying in theory.
Let your
Hey,
lawyer
hold on,
talk,
hold
Jeremy.
on. Let's back up. The court's familiar with maintaining property. The court's is familiar with maintaining fence lines on property. It's not a foreign concept.
Okay.
What would be a foreign concept is why, even if 70 acres, make it 170 acres, you enter, let's say it's a north, south, east. Let's say what you're calling the main entrance. What side is it on? What side of the property? East, west, north, or south?
It would be east.
Okay, so let's call it the eastern main entrance. If you entered on the complete opposite western side of your property, as inconvenient as that is, can you not drive from the western edge all the way to the edge of your deeded property on the eastern side? Even if it puts you within 500 feet, but so long as you remain on your deeded property and not otherwise violate the terms of the injunction that's in place, but at the same time, you not have to go on the main roadway that's on that east side.
Let me see if I can clarify again. I'm trying to follow your line of thought. Okay. So I have 70 acres, just so we're all on the same.
Jeremy, answer the question directly. He's being directly asked because what the judge here, he's looking to carve out this order. He understands that part of Jeremy's property is within the 500 feet restricted zone. She's saying, even though it's a pain in the ass to go a mile out of the way, if I say you are allowed to go on any part of your own deeded property, even though it's within the 500 feet, can you access it from the other entrance? It's a very simple yes or no question. Don't blow this by talking too much, Jeremy. Just say, yes, I can. It would be a major fucking inconvenience, but I can.
Page. I have 70 acres that has all the frontage on North Otter Creek Avenue. Then a year afterwards, they purchased 1.6 acres directly across the street from me. When I say eastern entrance, there are 3 eastern entrances and potentially 4 because I brought another piece of property. So all of those are on the east side of the property. Those are the only entrances to the property, and the only access that I can have to those entrances are from North Otter Creek. They don't have an access point in behind. And when you're saying, how could you not have access to all 500, or how could you not have access if you're on your property in the temporary injunction you placed in there 500 feet?
That's
Right now, right.
So
Okay, see, now the judge is getting angry because he's not answering the question. And even his lawyer's going, that's not what he's asking. He's asking, forget about the 500 feet thing. Can you get to every square inch of your property if you go through the other access point? If you go through the west side or the north, whatever side the other access point is on, if you can go through that, can you go anywhere on your property? That's all the judge wants to hear. Because if you say yes, he's going to say, all right, you can go anywhere on your property. You just have to go through the other entrance. Jeremy's on the verge of losing this by not answering the question directly.
I know what it says now.
So I can't access the property.
So-
The only access to the property in certain points is North Otter Creek
Okay.
Avenue,
Okay.
which is the public road, which
What's the road on the
All right.
western side that allows you access?
Okay, so he's saying the answer, he seems to be saying that answer is no. That there are some parts of his property that can only be accessed through the east side entrance that falls within the 500-foot restriction. So he's saying there's some parts of that property that can only be accessed through those entrances. And that's what they've, he's got to make that clear. This is where the lawyer should be talking. But I know the judge asked him, but this is where the lawyer should be explaining so that the judge better understands. Where'd that go? So someone asked whose dogs are those? Of course, those are my dogs, aren't you? That's Strawberry. Yoda went over back. Yoda just goes off onto the couch and falls asleep. So yeah, all right. So he just needs to be very clear and very specific with his answers. Either, yes, I can access every square inch of my deeded property from the alternate entrance. It's going to be inconvenience as hell for me to do it, but I can. Or he needs to say, no, I can. There are certain parts of my property that can only be accessed from the east entrances of my property. That's all he's got to say. I'm getting nervous here because I know what he's saying, and he's trying to say, but this judge doesn't like him. This judge doesn't like him. This judge doesn't like his lawyer, and this judge is going to be looking for every opportunity possible to, shit on him. And I don't want him to get shat upon by the judge. So I'm having anxiety.
That's clearly outside the 500-foot buffer. What would we call that? Is it?
there is no western road.
How have you been getting in when I?
There's 4 entrances on the eastern side. 2 of them are less than 500 feet.
All right. So
Or greater than 500 feet. Sorry.
if you go all the way around, there's one on the eastern side that's outside the 500 boundary, at least one.
Okay.
Potentially.
Okay, so on December 6th, I'm not incredulous because I don't believe what you're saying here. I'm just saying, I thought we went through this on December 6th, and what I heard on December 6th was, Judge, he will not have the ability to access his property. I said, well, can you access it from another way? Yeah, but I got to drive several miles
Yes.
around.
We said 1 mile.
Convenient, but you're going to have to deal with that. Now I'm hearing, but I can't even go on parts of my property. And I'm saying, okay, we can remedy that by allowing you on all pieces, every square inch of your property, even within 500 feet, if you're not otherwise violating the terms of the injunction, but still maintain that you can't drive in that way. You drive in the lawful way, consistent with the previous order. But if I modify it, I allow you then to drive all over every square inch of your property, even the parts that are within 500 feet, so long as you're not otherwise harassing, bothering, confronting, whatever. And so, again, maybe if I was there, I'd know what you're saying, but what you're telling me at the same time is you still have that ingress egress point, an inconvenient one, further distance away, but you can still, if you're asking for entrance to the gate, on the other side of that gate, although it could be 70 acres away, you come from the west to the east, right up until that inch.
I don't understand where we're having a breakdown in communication. There are access points only on North Otter Creek. The only access to my property is on North Otter Creek Avenue.
East.
That is
or
the
whatever.
only way to get to it. So if you're to
And
say,
is that
well, you
within
could go on your
500
70
feet?
acres and you could go, this is all brush. This is all,
Is that
I
within
haven't
500
cleared
feet?
that. There's only aspects where I can only get to the gates and the entrance on North Otter Creek Avenue. So if you're saying, hey, I'm going to give you access to all 70 acres, thank you. I appreciate that. I can't get to it unless I have access to North Otter Creek Avenue.
Okay, you might have just answered something that you didn't answer previously, and maybe it's because the question wasn't clear, which is parts of the property are inaccessible even
Yes,
if
sir.
you were allowed to drive across the whole thing.
Yes, sir.
Unless you go through that entrance.
Yes, sir.
And you said the word brush, I presume, so it's not all pasture.
Correct. It is woods. Some of it virgin woods still, untimbered
All right,
on purpose.
We know.
all right, I got you. So that's an inconvenience.
Oh, that's over here making Skeksis noises. Mm. Mm. Mm.
And what you're describing, okay?
She's
so
making dark
you
crystal
have-
noises over there.
Use the phrase, illegal or whatever. If you think the court's doing something illegal, you've got appellate remedies.
See, that's what I mean. Just answer the question short. Don't be putting in those words like illegal and whatnot, because that pisses off the judge. Ugh. Clients give me anxiety because they're the ones full of emotion, and that's what we as lawyers have to do a lot of times, to say, let me talk for you as much as I can. Your job, just sit there. My job is to take all of your stress. I will take all of your stress upon me. Give me your stress. Take it from me. Don't get agitated. I've got it under control. A lot of it is soothing your client, because it doesn't, it sounds cold to say, it doesn't really affect us as lawyers. It's just our job. We hear stories, not exactly like this, because this is a weird story, but we have clients in distress. We have clients in dire medical conditions. We have horrifically injured clients. We have innocent criminal clients. We've got people whose very livelihood and lives hang in the balance of the decisions. But we do that every day. That's what our job is. We're used to those feelings of anxiety. Let us feel and it's very easy to tell a client that. You just sit back. We'll take care of it. Don't worry. We'll let you know if there's something to worry about. It's very easy for us to say that, but it's very difficult for the clients to hear that, because it affects the clients in our life. To be honest, I don't know what Hales lawyers' practice is, but I'm guessing this, what the Hales thing isn't the most important case to him. But to Jeremy, this case is the most important case in his life. I get that so much from clients who, there are these tiny little things that really don't amount to much. They're absolutely annoyance cases to me. I've got some other client that's got $100 million deal on the line. That is far more important to me. But to this guy who's got the little $5,000, $6,000, $7,000, $8,000, $10,000 claim, in his life, that's the most important claim he has. So I have to balance that. I have to balance that out. I have to understand. Okay, I understand this is your most important case. I need to give you some attention and some love and some kindness, but I've also got other things that you don't care about, but they care about. I've got 50 clients that think their case is the most important case that I should be focusing 24 hours a day on. But you still, the lawyer has to settle down, just calm down, relax. Let me do my job. Don't get agitated, because if you get agitated, especially to this judge who does not like you, who actively is biased against you and doesn't seem to be really fond of your lawyer either. Every single little, ingress you give him, he's going to take it and he's going to bite it and he's going to use it against you. Don't make the judge hate you any more than he already does. And that's not just for Jeremy, that's for everybody. Just rein it in a bit and let your lawyer do the lawyer. If the lawyer needs something, he'll ask you.
Okay, I'm trying to fashion a temporary order. I would have said, let's come back tomorrow, the next day, or the next day. But now we got this discovery. The discovery, and I'm not criticizing your counsel's calendar is part of that. The need to respond in time to read and to waive and all those other things caused it to go to the 26th. My intent was not to go that far out, but it's necessarily now gone that far out. So it wasn't my intent to cause you any more. The fact we could have had to hear, we could have been over by now, and the court would have granted an injunction and we would have been discussing this, or denied the injunction and we would have all gone home with no restrictions. I don't know how that's going to end. We're halfway in. We're not even, I don't know if it's even safe to say halfway. We're partway through a trial. And what we're talking about is a temporary remedy. So I hear what you're saying. Do you have livestock on the property?
I do have birds, but Not livestock, if you mean cows, horses, pigs,
Birds are
Chickens and
livestock.
turkeys.
chickens and ducks.
I thought
Well,
Peacocks are up north.
Oh, peacock.
Okay. Let me hear from Ms. Preston. You're saying, ma'am, that you,
He's
Take
not being
issue.
honest.
I'm sorry,
There's no driveways in front of my property whatsoever. Nothing that he could drive into and access.
Good.
Nothing.
he's got chicken. Chicken, just for those of you that are wondering, chicken are livestock. Chickens are actually the largest form of livestock there is. Chickens are the largest numbered livestock on planet Earth. Just weird fun fact from farmland, Utah.
It's all woods. I even have a video of the whole entire thing
Oh, shut up.
across from my
All right, so hang
property.
on. Maybe it's
Here's
a
a diagram.
different definition.
It's
So, Mr.
2
Hales, when you
blocks.
say entrances on the North Otter Creek side, what do you mean? Are they gates?
She was a stripper.
I
She
have
knows
2
where all
gates,
her
and then I
entrances
also
are.
have drive-through areas. So the one particular
Not
area
true.
across from her 1.6 acres is an area where 3 different mobile homes used to be, to where I have access into that area.
That you could just drive right off the main road into
Yes.
the property?
Yes.
No,
Without
Culvert.
Left
Yes.
turn, his property, right turn into her property.
not
without a
true.
gate, but it's nonetheless.
Oh,
It is
shut
not
up, Lynette.
gated.
Okay.
There is gate. There's fencing, but there's not a swing gate in that area.
Right.
Preston, he's saying it's an
He's not being
entrance.
truthful. Across from my property, there are no way. It's all complete thick woods. He cannot drive in. His entrance to
You have
his
the woods
house.
here. Is there a fence that you know of that would?
Yes, there's a fence all the way along there. He can't drive through there.
Why do you think he's saying there's not a fence and that he's been?
I have a video if you want to see it. I videoed it, so I
Let's
can
see the
prove what
fence.
I'm saying right now on video. Because he kept saying that there was cameras across my property, so we videotaped every bit of it, looking for cameras on his property facing ours. There is no way he can drive in except for his driveway and where the tower is. There's an AT&T tower on his property, so there's a gate. That's way down at the other end of the road towards his schoolhouse.
Which would be outside 500 feet.
Right, way far away. And his driveway is way more than 500 feet. There's like 2 blocks away. There's Tina's got the house right next to his driveway. And it's like 2 blocks before you come to my driveway.
All right, so
And
here's.
Martha Riz just drove by. That's one of the things I filed. They drive by filming. That's why they want to
Who's
drive
they?
by. His girlfriend.
So if she's acting at the direction of
Yes.
Mr. Hales, then you could allege that as a violation of the terms
We
of the
did.
injunction because it includes language.
I have a video I can show you. There's no entryways across from my property. None.
She has multiple
And
entryways.
he can go right out of his driveway. He can come right out, swing left, and go boop, right to the highway. It's
Swing
just
left,
right there.
sweet
And we've been
chariot,
following it.
coming
we
for to
haven't
carry
even
me
gone out.
So there's no
home.
contact.
Swing
The prohibition
left,
against
Sweet
Mr. Hales includes
chariot.
other people unless such indirect contact through a third party was specifically allowed by this injunction, and there is no such thing that approves that.
No,
So
but
if
she
that's
does all
happening-
his videos, so.
That's an allegation that ought to go, if at
they
all.
They do lives together. They film together and they're on their lives on videos.
That's another
together.
allegation, and you know how to
Speaking of
access
which,
the courts.
the-
I know that because
The Hales, Jeremy, and George are going to be doing live with me tomorrow. Don't
So you
miss
can
it.
have number 5 and number 6
Script,
if you
script,
wish.
script,
Those will
script,
be
script, script.
investigated. And if it turns out that way, action will be taken or not, depending on how the evidence, plays out. So that's a separate issue. This is a very limited issue.
Right.
And it,
But I'm just showing you, and I have a video. There are no access points to his property in front of my
rather
property.
than what the court would need to do is have you show them the video and then authenticate it and then determine whether that video is accurate and make a determination of who's accurately describing what that is. The court's going to make a finding that
Jan Grint, I have
as a
no idea
temporary
why he
matter,
continues to allow her to
despite
talk.
the inconvenience, the court will modify the language to the extent that it'll allow access to all of your deeded property, even those parts within 500 feet, if you're not otherwise in violation of the terms of the agreement, but still maintain that your ingress and egress needs to be outside of the 500-foot barrier. And I'm not insensitive to that, but
I
the
wanna
fact of the matter is, in the balance of the need to access from a certain vantage point the piece of property and the inconvenience that it causes without allowing that, that's one of the consequences of the law that requires the court to have reviewed a petition, a supplemental petition, and a second supplemental petition to finally get to a point of temporary relief.
Judge, if I may, I don't think 500 feet, I don't think any of these entrances
Correct.
are within, they're all within the 500 feet. Maybe we just make it 250 feet or something like that, because the way right now, all of the entrances, that's what the confusion was. He has to go all around, because all of the regular entrances, this is what I've heard, we
Yeah,
put
but
them on
the
the road.
road is right up, her frontage of her property is on that same road. So
And
if
my
if
house
I give
is
him
close.
ingress and egress, he's driving past the front of her house.
But not necessarily. He can maybe, if 500 feet of her house, maybe make it 250 feet so we can use one of the entrances. Because what I'm hearing, we put him on the road, he just told me that all of the entrances on Otter Creek are within less than 500 feet.
No,
Some,
they're
one's
not.
100, one's 200, one's 300. There are none.
They're
Is
not.
that
Correct.
Yeah, so maybe make it 250 feet or something like that, Judge. Just maybe then that narrows the zone of entrance.
That wasn't suggested until.
Oh, no, I didn't agree. We got clarification here on this. I understand. So to access his property, if he's accessing his property,
But if he's driving on the main road that'll allow him access,
Otter Creek
while
Road,
he's doing that, right, on the
Okay.
Otter Creek, east side, are you driving on a road that fronts the property of Ms. Preston?
Yes,
at a certain point, you are,
Right.
you are, yes.
and he doesn't have to.
That's the problem that the court's trying to avoid temporarily.
But can we, but to accomplish both objectives, Judge, maybe if it's 250 feet and then that allows the entrance that's 350 feet away, him to come on Otter Creek Road.
But how does he get to it without driving right past the front of her house?
Can you get to
It's
it?
like a
Can
freaking
you get to
story.
any
This is like a
entrance?
mass
Yes, I can get
story
to two
problem.
under 250 feet. The entrance that I need specific.
God damn it. All right, I've had enough. Judge, here's what you're going to do. You're going to tell both of them to equally contribute. They're going to both pay equally for the services of a surveyor who is going to walk out there. They're going to survey the goddamn property of both of them, find out exactly how far it is from any given point on her frontage road to his frontage area, and whether or not he is able to access any gate within 500 feet of each other. You're going to have a hearing in 2 weeks. You're going to come back. The surveyor is going to give his findings, and you're going to decide, is there a gate that's outside the 500 feet mark that he can use? And then you're going to make a goddamn decision. I'm tired of listening to both sides of these people just bullshit and bitch and moan at each other, and the judge going, well, I don't know, maybe it is, maybe it isn't, I don't know. Let's all fucking find out. Let's all fucking find out exactly how far everything is from everything else and make a goddamn decision. Judge, I've had enough. I've had enough. Appoint a surveyor, Judge, so that you can find out what the fuck is actually going on and you can make a goddamn judicial decision. How about that? That would solve all the problems. You can say, Jeremy Hales, shut up. Lienette Tortoise Queen, shut up. We're going to turn this over to a surveyor. He's going to find out exactly how far it is away. And then I'm going to decide what to do, because I'm the judge and I'm not going to give you I'm not going to pontificate as a law professor here. I'm going to give a judgment, and you're both going to fucking deal with it or take it up to the higher court, because I'm sick of this shit. That's what you're going to do, Judge. Right? Right? Somehow I have a feeling that's not going to happen. Look at this. I got 2 hours and 3 minutes without a serious rant. I almost made it. This close. This close. I'm 9 minutes away and I ranted.
Specifically for a project for my own security, for my own property, is right across from their property.
Okay, how is it now a security issue that you have to get access to that spot?
That's not something I feel comfortable sharing with currently.
No,
It wouldn't be secure.
No,
It wouldn't be
you
a
gotta
secure
tell the judge.
thing if I was sharing openly what my security measures were.
Between now and January 26th, you're going to have that risk.
He's already said on the video he's going to put
Preston.
cameras up to watch my property.
Ms.
Preston,
President,
there's no need
shut the fuck
to
up.
make further comment.
Right.
So the court is going to enter a second extended temporary injunction.
Wait, one more time, just to make a record, if I could. So we're just going to say that because we're on the 26th, that's a brief enough time just to temporarily extend it. I'm just wondering in case anything, God forbid, happens, if we keep pushing it.
One of two things is going to happen.
What if
I
somebody
hope one of
dies?
two.
You know, I'm just, you know.
Okay, unexpected things occur. But either this court's going to dismiss the case in its entirety.
Hey, Liz. Liz is here. Liz, Jules was looking for you earlier today.
Basis to
Got it.
enter an injunction, and then we're going to discuss what those terms are.
Got it. Okay.
In light of the case that happened 6 days ago, the case that'll happen between now and January 26th, if any,
Okay.
and in light of the facts and circumstances of the case, which is going to include this same discussion.
Yep.
There are people with injunctions until further order of the court, in effect, almost potentially permanently, that still live together as neighbors with ingress, egress restrictions, time restrictions, those kinds of things. It can still be accomplished, but it may not have to be accomplished or addressed if in fact there's not a competent substantial evidentiary basis to implement the injunction in the first place.
Understood.
We're just not there yet.
Right.
And Your Honor,
So-
I'm very sorry that my mother has stage 4 COPD.
Okay. I'm not laughing at whatever her mother. What is COPD? COPD is chronic obstructive pulmonary disease. Okay. That's sounds lung cancerish to me. Again with the mother. She just ghosted the judge on she ghosted the deposition because her mother was being put on life support. Her mother was dying and she had to get there to say goodbye to her mother. Then 2 weeks later, well, we haven't even got there yet. This was just the other day. Now, so she had to ghost them. And then now she's saying she has stage 4. All right, the mother timeline here. We had the hat trick yesterday. One more mother quote, and we're going to get the turkey here. First off, she couldn't be to the deposition because mother is dying. She has to get to mother in Naples, Florida, so that she can say goodbye. Mom is on life support. Now, today she's saying mom's got stage 4 and there's all these problems. 2 weeks from now, within 3 seconds, she says, my mother died. Your mother died? No, my mother's not dead. What is your mother? Is your mother dying on life support? And does she just have stage 4 and she's in hospice, or does she even have stage 4? Is she dead? Is she alive? What is it? Stop just saying shit. Stop saying shit and just tell us what the real deal is.
Basically died and was recessed 3 times.
Okay, now she's dead and came back to life 3 times. Right, okay.
I'm sorry that happened, but that was beyond my control. And had it been his
How
mother,
is that relevant to what's going on?
because had it been his mother,
Okay, score 1 for the judge. Okay, how does your mom die and have anything to do with what we're talking about here now? Okay, score 1 for the judge. The judge gets a point for that.
I would have gratefully and gladly said, go be with your mom. We'll finish this later.
It's not relevant to the
I'm
issues.
just saying.
Well, you're just saying. Just saying something that's not relevant is unnecessary.
I'm sorry. I didn't do it on purpose.
Yes, you did.
Well, if you have no control over what you're saying in court, in open court of record, then
No,
who
I mean,
has
I
control
didn't
over
go
that?
I didn't have to leave. I'm sorry. I should
Shut
have
up.
came to court and let
Yes, you
my
should
mother
have.
pass. And not-
Your mother didn't pass.
Well, that's not.
Your mother's still alive 2 weeks later when you give your deposition. Your mother's not dead.
Shut the fuck up.
not a sentiment shared by the court. To the extent that, and I don't know that anyone's advanced argument to that point. It's just not relevant to these proceedings. It's very relevant in the big picture of your life. I understand that, but you don't need to keep telling me that. And multiple times, I'm going to quit saying it. I'm
No,
not
'cause-
insensitive to that. I understand what you're saying. I haven't heard anyone argue against that.
I
They
know,
have
but you
asked
said I
for
have
you
to-
to establish corroboration that in fact you were addressing those things like you said, which
Right.
led to a continuance and a discovery problem. That's all
And
been
I
done.
need to bring you proof, otherwise I'm being charged money to pay
Yes.
his legal fees for
Because
it.
as you
So I will
should,
do
you
that.
ghosted a fucking
It's
deposition.
not, no, and one thing doesn't cause the other. One thing might
You
cause,
ghosted
or
a
not complying with
deposition.
it might cause an evidentiary hearing on if and to what extent you might be responsible. So yeah, there are potential sanctions there, yes. I haven't decided that there are and what they would be if there are.
Not dead yet.
I will get the proof.
I'm getting better.
So
I feel happy.
multiple times to be as specific as I can with everybody. Okay? I don't want there to be misunderstanding. What is currently in place is an extended temporary injunction. It's going to become a second extended temporary injunction through January 26. There's going to be an addendum to it, just like as there was previously. It includes the language, as I said, that is directly drawn from the Budlove versus Johnson decision, decided 12/29/23, the second DCA. Additionally, the court's going to modify.
You just said you understood. Now you don't. She's a pathological liar.
I'll tell you what section it's going to be in. It's going to be the 500 feet. So the no contact
All right. Looks like the judge is going to carve out that exception.
within 500 feet.
You get.
There's a, trying to figure out where there's a place to put unless.
Shirley Montoya says the judge only requires her to bring a
I don't know if
gas
this
station
form allows you
receipt
to type in
after everything you put Jeremy through. I
line
hope
that
you're
I'm
not
gonna
telling
line
me the
to fit
truth,
in there.
because after everything you put Jeremy through, if he accepts only a gas station receipt from her, she could have gone to Naples, Florida to see her sister because she didn't want to be deposed in her deposition. It may have nothing to do with her mother. I want to see her mother's hospitalization records. I want to see evidence her mother was on life support. I want to see evidence that she actually showed up at the hospital to visit her mother on life support. I hope you're wrong. I know you're not, but I hope you are. Come on, Judge. Do-do.
I'm an optimist too.
Come on. All right, how long is this? We've got like 3 minutes left. How much of this 3 minutes is that?
Repeat myself, but again, Mr. Hales, you're entitled to be aware that violation of any of the terms of this now second extended injunction with the addendum and the modification to the distancing that we've just discussed, it's been orally pronounced a record and it'd be reduced to writing, and you'll be provided a copy here today. Any violation of that, as you know, will be alleged as a potential violation and will be proceed in that manner. You understand that potential? I need you to answer out loud.
Yes.
Okay, I just want to make sure that it's clear for the record. Is Preston anything further to come before the court on your behalf?
No.
Okay, anything further, Mr. Shockett, on your client's behalf?
No, Your Honor.
Thank you all. Stand adjourned.
Oh, thank God. Hopefully there's nothing else there. We're not going to miss anything. You got to find your way out. Oh, my Lord in heaven. Sweet baby jumping Jehoshaphat. All right. We got a few super chats and other things that have been neglected for a minute. So let me get those taken care of. Kitty, who's been a member for 13 months, says, congrats, Vices. Oh, thank you very much, Kitty. Thank you. That means a lot to me. Thank you for being a supporter for more than a whole year. It's like a long damn time. Thank you so much. Bifron says Jeff has uploads from like 17 years ago. Yeah, like way back in the day when I was the president of a motorcycle club here in Korea. We had a web page and I used to upload videos to YouTube so that they could be incorporated into the web page, or spoiler alert, MySpace page. It was a long time ago. But yeah, so if you go back into the ancient stacks and stacks of Wicked Wax, there's some old motorcycle videos of me, like a long ass time ago. But the law racks, the legal vices incarnation has been around since May 2nd of 2022. So we're coming up on the 2-year anniversary. Don't miss that, because that's going to be a big effing blowout. We're going to, I just hit a button I shouldn't have hit. Gosh dang it. Let's see. Alan 69. I've got to find this here. I unclicked something and took it off my radar. It was Kitty. Kitty has been a member for 13 months. Congrats, Vices. I don't think I did that. All right. I guess I didn't unclick something. If I missed something, I'm sorry. But Alan with the $2 super chat again. Been here since day one, and I'm proud to say it. Cheers. You are the OG of the OGs, Alan. Thank you so much for sticking with me through all of my stuff and all of your stuff. We're still here together, brother. Thank you very much. Bad Duck for the $5 super chat. Thank you so much for your support. Simply put, his property has fences, woods, creeks. He can't access all of his property from one entrance. That's all he has to say. That's all he has to say. Don't get agitated. Let your lawyer do the lawyering. That's what you're paying him ridiculous amounts of money for. Marcus King became a YouTube member. Marcus King has become the newest member of the Clean and Sober crew. Thank you so much, Marcus King. I appreciate it. I hope you stick around for a while. We'd love to have you here. Jill Ems. I don't know why that Emma. Jill Ems. She turned away from the light yet again. She's a dark creature. She's a creature of darkness. Thank you, guys. We hit 70,000 subscribers today, and it's all because of you. We're right now at 70,063. That is so cool. I'm so grateful to each and every one of you. But right here, we've got our like and subscribe poll. We're going to shut this down right now. Who is your favorite character? Who is your favorite character to like? Yeah, who's your favorite character in this Shakespearean tragedy? 17% of you said Lienette is your favorite character. 13% of you said Judge Grudge is your favorite character. Only 7% said Septic Boy was your favorite character. But I think because most of you can't stomach saying the word Lienette and favorite or Judge Grudge and favorite in the same sentence, 63% of you have said the tortoises are your favorite characters in this thing. That's the end of the poll. That's the end of the like and subscribe poll. We're going to shut this down now, and we're going to go over to Megan Fox. We're going to go pay Megan Fox a visit. She's not doing the Hales today. She has Dave Neal from the Bachelor Nation on. Dave Neal is covering this case of Clayton Eckert, who was a bachelor on the show The Bachelor, who was accused of impregnating this woman with twins after getting a couple of blowjobs one night. So her case has fallen apart. There's weirdly similar parallels with Lienette and Jane Doe, as they're calling Laura Owens, over in the Tonsil twins, or as I call them, the Schrodinger twins. The Schrodinger twins. But yeah, so he got a couple blowjobs from this woman, and 5 days later she was pregnant with twins, according to her. And there's medical record falsifications. There's fraudulent documents. There's, as they call them, arts and crafts put together. But Megan Fox has Dave Neal, who is covering this, who's covered it from the beginning on his channel. We're going to go over there right now, and I'm going to join them for a little bit too. For the fetal attraction case. And as I said, Friday is going to be the effort Friday. We're going to have a huge panel on where I'm just going to try to grift as much money from you as possible. I just try to do that once a month. And we'll do shots for money, have a great panel of guests, have a whole bunch of fun to celebrate 69,000 subscribers, even though we already have 70. 69 is a much better number than 70. We'll do that Thursday. We're gonna do some O.J. Simpson, the closing arguments in the O.J. Simpson trial from 1995. But tomorrow, Jeremy and George will be right here. We'll have Jeremy Hales, George, both of them will be right here on my channel. We'll have a great discussion. We'll fill in some blanks, and we'll have a good chill stream with Jeremy and George tomorrow. Don't miss it. It will be at the same time, 9 a.m. Eastern. Jeremy and George right here with me on this channel. So have a super amazing time. Let's all go over and say hi to Megan. All right. Take care, everybody. We'll see you tomorrow where I will be joined by Jeremy and George. Love y'all. And thank you so much for getting me to that 70,000. You guys are the most awesome mods. You are the best mods on the internet. And chat, you are the Vice Squad. You're the Vice Squad. You're the greatest chat, hands down, on YouTube or anywhere else on the internet. Thank you so much for your support. Thank you so much for being here. Thank you so much for the super chats, the memberships, and just chatting. We'll see you tomorrow. Larak saying peace, oot. That's my Canadian impression, in case you didn't know.